viewers, a very warm welcome to you. Welcome to the session on understanding gender in law. We were discussing Indian legal system where the judiciary plays a very important role. So, in this session we will be discussing about the judiciary, the judicial system in India. India has adopted a federal system of a government which distributes the law enacting powers between the center and states. The Constitution of India provides for the framework of Indian judicial system as a single integrated system, independent and separate from the executive and the legislature. The judiciary is that branch of the state which reviews and interprets the law. The objective of this session is to discuss the role of courts in India, to determine the hierarchy of courts in India, and to discuss in brief the powers and functions of the courts. The judiciary plays an important role in dispute resolutions. The judicial system provides a mechanism for resolving disputes between citizens and government, between the two state governments and between the center and state governments also. Judiciary is treated as a final interpreter of the Constitution. The judiciary has also power to strike down particular laws passed by the parliament if it believes that these are violation of the basic structure of the Constitution. In earlier videos, when we were discussing about the Indian legal system, we have discussed about the Constitution and the Parliament and the law making power of the Parliament. But when it comes to the judiciary, it is said that it has only power, the judiciary has only power to strike down the laws which is passed by the Parliament if in case they violate any fundamental right or any basic structure of the Constitution. So, this is called judicial review. Now, another important function of judiciary is upholding the law and enforcing the fundamental rights. So, every citizen of India can approach the Supreme Court or High Court if they believe that certain law violates the constitutional values and their fundamental rights have been violated. Now, one of the aim of this session is also to make the learners aware of how the hierarchy of courts is existing in India. So, there are three different levels of courts in our country: Union Judiciary, which we say is Supreme Court, High Court in the states, and the subordinate courts. There are several courts at the lower level, because at lower level mostly there are number of courts, and at most common people, mostly all the people approach the subordinate or a district level or a district courts. So, they are usually at the district or tehsil level or in towns, and they hear many kinds of cases. Each state is divided into districts that are presided over by a district judge. Each state has a high court, which is the highest court of that state. At the top is the Supreme Court, which is a single court that is located in New Delhi and is presided over by the Chief Justice of India. The Supreme Court of India, which is the apex court, was inaugurated in on January 28, 1950, and we can say it is a primary guardian of the Indian Constitution. If we look into composition, the Supreme Court originally consisted of a Chief Justice and 7 other judges, Article 124 of the Constitution. But the strength has been increased several times by the acts which is passed by the Parliament, and presently it consists of a Chief Justice of India and not more than 25 further judges. The law which is declared by the Supreme Court is binding on all the countries within its territory. This is as per the Article 141 of the Constitution. Qualification and appointment of Supreme Court judges. Now, to be appointed as a judge of Supreme Court, a person must be a citizen of India, must have been a judge of High Court or of 2 such courts in succession for a period of 5 years, or an advocate of an High Court for at least 10 years of experience, or a distinguished jurist can also be appointed as a judge of Supreme Court. Now, there is no minimum age as such fixed for the appointment of judges. However, the Supreme Court judges are appointed by the President and they retire at the age of 65 years. However, one can resign from office earlier also by addressing his or her resignation to the President. The Chief Justice of India is appointed by President in consultation with the judges of Supreme Court, and as per the convention, generally senior most judges of the Supreme Court are elevated or usually appointed as a Chief Justice. The President, in consultation with the Chief Justice of Supreme Court, appoints the other judges of Supreme Court. The Constitution, through its Article 124, Clause 6 and Clause 7, it prohibits a person holding office of Supreme Court judge from practicing law before any court in territory of law. So, when you are a judge, when a person is a judge of a Supreme Court, so they cannot practice law in any other courts or in the territory of India. Now, even the judges can be removed. So, a judge can be removed, may be removed from his office only by the order of President on the ground of misbehavior or incapacity, but the removal is possible only through regular procedure which is laid down in the Constitution. If the two houses of Parliament, supported by a majority of total membership of that house and by a majority of not less than 2/3 of its members of each house present and voting, then which recommend the President for removal of the judges from office, then only a judge can be removed. So, a procedure of law has to be followed for removal of a judge. The seat of the Supreme Court is at Delhi, but the Chief Justice of Supreme Court, with the previous consent of the President, can enable the Supreme Court to sit elsewhere in India besides Delhi. Now, if it is very important to, so far we have discussed the composition and how the Supreme Court judge can be appointed or where the Supreme Court sits or where the seat of the Supreme Court. But the very important aspect is the jurisdiction. Now, jurisdiction, or we can say the official power to make legal decisions of the Supreme Court, can be broadly categorized as follows, like original jurisdiction. The original jurisdiction of a court is power to hear a case for the first time. So, Supreme Court is also having original jurisdiction. It is not only like the court has to go through district court, then high court, then the Supreme Court, but the Supreme Court has an original jurisdiction also. These are of the three main types. Between, when there is a dispute between, how can they exercise the original jurisdiction, Supreme Court, when there is a dispute between the Government of India and one or more states, between the Government of India or any state or states on one side and on one or more other states on the other sides, or there is a dispute between two or more states. So, every citizen of India can also approach to the Supreme Court for enforcement of fundamental rights with what are known as writs. So, there are certain writs under which the citizens can approach Supreme Court for the enforcement of their fundamental rights in cases of violation. So, Supreme Court here has the original jurisdiction. Then the Supreme Court has appellant jurisdiction. The Supreme Court can review cases from lower courts. So, there are four types of appeal, like it is not like each and every case is open, but four types of appeal can be made to the Supreme Court once if it relates to the constitutional, civil, criminal or a special leave petitions. A citizen can also appeal to the Supreme Court in order to protect their fundamental rights. Then the Supreme Court also exercises advisory jurisdiction. The Supreme Court has the power to give its opinion on any question of law or fact of public importance as may be referred to it by the President. So, President can always seek the opinion of Supreme Court if it has to determine that there is some question which relates to law, or the question is related to fact, or it is of very public importance. So, President can ask Supreme Court for give their advisory jurisdiction on that particular issue. Now, there are many other powers and functions of the Supreme Court. Article 129 declares that Supreme Court is a court of record. Now, what is court of record? The decisions of the Supreme Court are recorded and these forms precedents for other cases of similar natures. If any person, body or institution of the country shows disrespect to the decision of Supreme Court, it can institute the contempt of court proceedings against that person or that body or institutions and punish any person guilty of contempt of its authority by fine and imprisonment. So, it is a court of record where the various cases which form the precedent. When we say precedent, that means there is a settled point of law which is binding on the other courts, the lower courts, high court or other courts. The decision of Supreme Court is binding on all courts within the territory of India. However, the Supreme Court is not bound by its earlier decision. Now, whenever the Supreme Court is taking any decision, and settle some law, the doctrine of stare decisis becomes applicable, and it is also binding on all courts within the territory of India. But the Supreme Court itself is not bound by its earlier decision. It can also come to different decision if it is convinced that it has made an error or it harmed some public interest. So, it can also review its own decision. The decrees and orders which is issued by the Supreme Court, they are enforceable throughout India. Supreme Court can make rules regarding the practice and procedures of the court with the approval of the President. The Supreme Court can appoint its officers and public servants in consultation with the UPSC and determine their conditions of service in consultation with the President. The Supreme Court looks into the disputes regarding the elections of the President and Vice President. So, Supreme Court has very wide powers. It can also look into the disputes. Supreme Court can recommend the removal of chairman and the member of UPSC to the President. Now, Article 139A, which is inserted by the 44th Amendment Act, it says the Supreme Court may transfer to itself the cases from one or more high courts if that involve the questions of law or it was of great significance. Supreme Court may transfer cases from one high court to another in the interest of justice. So, Supreme Court, it has power if it feels that there is a question of law is involved or a question is of great importance or a significance, it can transfer to itself the case which is pending before any court, any high court. So, Supreme Court can also transfer cases from one high court to another high court also. This is all to maintain in the interest of justice. We have given a brief idea of Supreme Court and its jurisdiction, though we have not gone much into the details of the Supreme Court, but the Supreme Court's exercise of original jurisdiction and appellant jurisdiction and other powers. Now, we have given a holistic view of that. It is also important to determine the second level of hierarchy of the courts is the high courts. Now, high courts, Article 214 to 231 of the Constitution deals with establishment of high courts in states, how the judges are appointed to the high courts and what are the powers of high courts. Now, generally each state has a high court. Every state is mostly having a high court, but in some situations several states or union territories, they can have a single high court. Now, so far the decisions of high court is concerned, they are binding on the subordinate courts within the same state. We have discussed that when the decision of a Supreme Court is binding on all the courts, which is inclusive of high courts or the lower courts, though it may not be binding on itself on the Supreme Court, but the decision of high courts, they are binding on the subordinate courts within the same state. High courts have power to issue 5 types of writs for protecting the rights of people. The writ power is also with the Supreme Court and also with the High Court. So, both the Supreme Court and the High Courts, in case of any violation of fundamental rights, the person can approach to the courts for protecting their fundamental rights, and under Article 226, High Court can give them relief, and it has also power to issue the writs, maybe a writ of quo warranto, mandamus, prohibition. So, there are 5 writs which High Courts can also issue them. The High Court basically stands at the head of state's judicial administration. There are 24 high courts in a country, 3 having jurisdiction over more than one state. So, yes, each state has its own high court, but in some places one high court may have jurisdiction for over more than one state. Among the union territories, Delhi alone has a high court of its own. Another union territories which come under the jurisdiction of different state high courts. So, each high court comprises of now what is the composition? Now, composition of high court, if we look into, the high court comprises of a chief justice and such other judges as the president may from time to time appoint. Now, how they are appointed? Chief justice of high court is appointed. So, chief justice of high court is appointed by the president in consultation with Chief Justice of India and the governor of the state. The procedure for appointing the peony judges is same except that the Chief Justice of High Court concerned is also consulted. Now, if they are appointing the judges of a particular High Court, so Chief Justice of that High Court is also consulted. How much time, what is the retiring age of the judges of the High Court? So, they hold office until the age of 62 years and they are removable in the same manner as the judge of Supreme Court. So, in cases of misconduct or a misbehavior which has to be proved and it has to be decided in the parliament by majority voting, then only they can be removed. To be eligible for appointment as a judge, one must be a citizen of India and they should have hold a judicial office in India for 10 years or must have practiced as an advocate for a High Court or 2 or more such courts in succession for a similar period. So, he first of all condition is citizen of India and should have should hold any judicial offices for 10 years as an advocate of High Court. Now, each High Court has power to issue any person within its jurisdiction directions, orders or writs, including writs which are in the nature of we were talking about the writs. So, what are the types of writs are there? Habeas corpus, a person is asked to be produced, mandamus, prohibition, quo warranto and certiorari for the enforcement of fundamental rights and for any other purpose. Now, the main function of every writ has its own function. So, main is there should not be violation of fundamental right and for the enforcement of fundamental rights basically the courts, High Court or a Supreme Court they issues writ. Now, this power may also be exercised by any High Court exercising jurisdiction in relation to territories within which the cause of action wholly or in part arises for exercise of such power. It does notwithstanding that seat of such government or authority or residence of such person is not within those territory. It has no impact even if there is seat of the government or authority or a residence is not within those territories. There are 4 stages that each case goes through in every High Court. Like now, there are various stages when the when the case is filed. So, how the case is admitted in a High Court? First, it is admission, then orders, then comes the hearing, and the 4th stage is judgment. So, these are the 4 stages each of the case goes through in every High Court. Now, each High Court has power of superintendence over all the courts within jurisdiction. That means the court can they can superintend the lower courts which is falling within its territory or within its jurisdiction. It can call for returns from such courts, make and issue general rules and prescribe forms to regulate their practice and proceedings and also determine the manner and form in which the book entries and accounts shall be kept. So, how it is exercising control over the lower courts, that it can also make rules and prescribes general rules and prescribe certain forms and determine the manner how the book entries should be looked into or how the account should be kept. Now, we have discussed Supreme Court is at the apex level, then comes the High Court level, then comes the district and subordinate courts. Now, courts that function below the High Courts are properly known as lower courts, district courts. The subordinate courts are established in each district of the state. The structure, hierarchy and number of courts in the subordinate courts, they vary from place to place because it depends. Usually matters are distributed between either civil court and session courts. So, session courts generally they take up the criminal cases and there are also certain courts which take into account the civil cases, they are in the nature of civil courts. Now, fundamental difference between High Court, Supreme Court and subordinate court is that High Courts and Supreme Court they have power to interpret the law and declare them invalid. So, interpreting of the constitution or a question which relates to question of law or fact lies with the Supreme Court and High Court and they can interpret the law and declare them invalid. But the subordinate courts they only have the power to apply the law to the cases and give a decision. So, what the subordinate court is doing is whenever the case is filed before the subordinate court, they look into the provisions of the applicable law, what the choice of law is with them, and then they have to declare or decide that particular case according to the law which is made by the parliament. What is the law existing on that particular point? They also refer to precedents or the judicial decisions which has been already has settled point has been settled by the Supreme Court decisions. So, or if there is any case laws on the same subject which is decided by the High Court of that state. So, they can also refer to those cases. The subordinate courts are bound to follow the decisions of court higher than them. So, they do not have the power to declare a law as invalid, but they have to follow the decisions of the court higher than them. The tribunals, however, is also one of the mechanism where the specific cases have been dealt upon. Tribunal means a seat or a bench upon which judges sit in a court and a court of justice, but that meaning is very wide, including even ordinary courts of law, whereas in administrative law the expression is limited to adjudicating authorities other than the ordinary courts of law. So, examples of some of the tribunals we can say is Central Administrative Tribunal for resolving the grievance and dispute of central government employees, state administrative tribunals for state government employees, the Telecom Dispute Settlement Appellant Tribunal for resolving dispute in telecom sector in India, National Green Tribunals for disputes involving environmental issues. Similarly, Motor Accident Claim Tribunals deals with the matters relating to compensation of motor accident victims or their next of kin. So, there are so many tribunals which are existing in India for a specific cases, to deal with specific cases. Some of these tribunals function with regulators also. So, regulators are specialized government agencies that oversee the law and order compliance in the relevant government sectors. For example, one of the tribunal which is TDSAT, which functions along the regulator TRAI, that is Telecom Regulatory Authority of India, in formulating laws and policies for resolving the telecom dispute in India. Therefore, these tribunals complement and supplement the role of courts in maintaining law and justice in the society. So, we can conclude, we have discussed the powers and functions of hierarchy of the courts, Supreme Court, High Court, subordinate courts, and also how the tribunal play important role in maintaining the justice. So, the judiciary we can say is that branch of the government that interprets the law, settles dispute and administers justice to all citizens. The judiciary is considered the watchdog of democracy and also the guardian of the constitution. For democracy to function effectively, it is imperative to have an imperial and independent judiciary. Thank you.